Docue is the modern contract management platform that automates lawyer-made templates in a few simple clicks, helping businesses ease admin, boost sales, and streamline the paperwork no one has time for.
Hi everyone, so thank you for joining us today. During today's webinar, we're going to be discussing some of the key legal documents that SaaS providers need, with a particular focus on SaaS agreements themselves. Before we get going, just some very quick housekeeping. So we should have time at the end to do a Q&A session. So if you do have any questions as we go through the content, please do just pop them into the chat. The webinar is being recorded, so the recording and also a copy of these slides will get sent out to you after the webinar, so you'll have them for future reference. So before we get into the main content, we're just going to do some very quick introductions so you know who's speaking to you today. So Ashleigh, over to you to go first.
Yeah, of course. Hi, I'm Ashleigh Evans, legal counsel at Docue UK. So my background is primarily in tech and commercial law. I've been with Docue for 2 years now, coming up to. And along with Heather, I create, code and maintain the legal templates on the Docue UK platform. And prior to joining Docue, I actually worked at a law firm that predominantly serviced Microsoft partners.
Thanks, Ashleigh. And I'm Heather Stark, Head of Legal at Docue UK. So I'm also a commercial and technology lawyer by background, and I've been at Docue since we launched in the UK a couple of years ago as well. Let's get started. I'm going to pass you over to Ashleigh, who's going to talk you through some of the key concepts in SaaS agreements. And then afterwards, I'll dive into IP protection and some of the other legal documents that you need as well.
Sure. So I will just run through the objectives of this webinar first. So firstly, we'll kick off with talking about why it's important to have a written SaaS agreement and also some of the key clauses that they include. And then we'll also walk you through how to structure your liability clause to protect your business. And then secondly, we'll learn how to protect your IP using a SaaS agreement. And then finally, we'll also talk about some other legal documents that we think are relevant to SaaS products that you might find helpful. So let's get started with the benefits of having a written SaaS agreement. So first, to understand what the benefits of a written SaaS agreement are, let's just define SaaS. So SaaS stands for Software as a Service, which is a cloud-based software delivery model where apps are hosted and maintained by a service provider, and then those apps are accessed via the internet, and that's usually on a subscription basis. So some great examples of SaaS are Slack, Zoom, HubSpot, Netflix, even this platform StreamYard that we're streaming this on now is a good example of SaaS. And your SaaS agreement is the contract that governs the use of those types of cloud-based software services. So why are these agreements so important? Well, firstly, they're a tool to manage your clients' expectations. So your SaaS agreement should essentially be like a roadmap for what you'll provide, the fees payable, and also what happens if things don't quite go to plan. Secondly, in that same vein, they're there to protect your business. So they help you ensure that you get paid. Also, they include legal protections, things like limitations of liability. They ring fence your IP, and they're also there to help you comply with legal requirements. So it's super important to have a written one in place, but what should actually go in them? So moving on to the key elements of a good SaaS agreement. So firstly, your scope of service. So your SaaS agreement needs to have a very clear and detailed description of the software that you supply. Also, if you offer additional support services, so things like maintenance or bug fixes, also make sure that you outline these in your SaaS contract. Also, another very important thing, if your SaaS product incorporates third-party software, then you must include any relevant third-party terms required by that third-party supplier. So, for example, I know when I work closely with Microsoft partners, in the Microsoft partner agreement, it was a requirement that they flowed down the Microsoft customer agreement terms. So just always check if it's necessary and then flow them down. Secondly, the right to use the software. So sounds super obvious, but a good SaaS agreement should grant the license to access your software and then also set any restrictions on the client's use of it. So things like no sub-licensing, access to third parties or giving away your password. Sounds kind of obvious, but it's good to state these things. Also, if you want to get more into the back end of things, no reverse engineering or decompiling, or just generally modifying the software. So once you've set these boundaries, then you can start thinking about other parts of your agreement, like setting your pricing model. And of course, depending on your business or the kind of software that you provide, it will vary, but your agreement should clearly set out what your subscription model is and also your pricing model. So you can see here we've listed some common ones, but it's just important to make sure that you clearly set out the fees your client will pay, how they'll pay them, and then also what the consequences are if they fail to pay that on time. So now let's move into the more legal elements of a SaaS agreement that are there to protect your business. So firstly, term and termination. So the term of your contract is how long the SaaS agreement will last for. Now, usually with SaaS agreements, you'll see a fixed term, so something like maybe 12 or 18 months. And then a lot of suppliers will opt for the contract to automatically renew after that period ends, unless a party decides to end it before then. But your termination clause should then determine how either party can get out of the agreement if things don't quite go to plan. Next, on to warranties and limitations. So warranties are contractual promises or they're statements of truth given by one party to another. Now, if these statements turn out to be untrue, then the other party may be entitled to compensation or other legal remedies. And so for that reason, warranties from a supplier's point of view can be a bit of a risk area. So while it is really common for customers to request that suppliers give warranties to assure them about things like the reliability or quality of your SaaS product, because it is SaaS by its very nature, there are so many external factors that can affect their use of that software. And so for that reason, it's really essential to sort of balance what falls within your responsibility with clear limitations or disclaimers setting out what actually shouldn't fall under your responsibility. So since SaaS is hosted online, it's really important to specify things like internet outages or third-party disruptions that are so outside of your control and therefore just shouldn't be your responsibility. So a really common term that we see in SaaS agreements is an as-is clause, which essentially states that the software is provided as is. So it makes it clear that the software isn't guaranteed to be error-free or uninterrupted or perfectly suited to every customer's specific needs. So by including these kind of disclaimers, you can shift some of that responsibility from yourself to the customer to make sure they're responsible for checking that the software actually meets their required needs. Which leads me quite nicely on into liability. So aside from those other key protective terms that I've just talked about, like your limitations and your disclaimers that are sort of scattered throughout your SaaS agreement, your limitation of liability clause will kind of be the bulk of your legal armor that protects your business. So your limitation of liability clause restricts how much a party to the contract can be held financially responsible for if something goes wrong. Now, in the UK, the compensation that you may have to pay if you're sued isn't necessarily tied to the value of the contract, which means that without a good limitation of liability clause, you can be on the hook for an unlimited amount if you breach that contract. So you know you need one, but how do you structure your liability clause? Well, as a SaaS provider, I'm going to talk about two key elements in this clause that are really, really important for protecting your business. So the first is a liability cap. And a liability cap limits the amount that you could be sued for if you breach the SaaS agreement. So it sets that maximum amount of compensation that you'll need to pay if your customer suffers any losses or damages due to your wrongdoing under that contract. So let me give you an example. Let's say your SaaS agreement says the supplier's liability is limited to £100,000. So that £100,000 is the maximum amount that you can be sued for under this contract. Well, with that being said, there are certain liabilities that can't be limited legally. So things like death, personal injury, fraud. But when it comes to breach of contract, your liability cap is a really good way of setting that maximum amount that the other party can sue you for if you breach your SaaS agreement. it's a really good way of quantifying your risk. So say an investor or a potential buyer is looking at your business and they want to know the risks associated with your contract. They can literally pick up your contract, look at your liability clause and be able to see what that cap is, quantify that risk. So, you know, you want a liability cap, but how do you determine what that level should be? Do you pluck it from thin air? Like, I can understand that it might be a bit of a difficult one to put your finger on at first. So we'll give you some of our top tips. So firstly, make sure the cap is reasonable. It should offer a genuinely meaningful remedy for contract breaches. So what I mean by that is it shouldn't be zero. It has to be a reasonable amount. And a really good approach to this is by linking it to the fees paid or will be payable by the customer under that contract within a certain time period. So it's common to see liability capped at 100% or maybe 125% of the fees paid in the prior 12 months to the claim. And with that 125%, it would give the customer a full refund of the fees with also 25% compensation on top in the event that you've breached the contract. So that helps to support the argument that the cap is reasonable. Or with that being said, like I gave the example of earlier, you can have a fixed sum, so like that £100,000, and that's a better approach if you think the fees could fluctuate over time and you'd prefer a bit more certainty here. So it could be a fixed amount or you could link it to the fees, but ultimately your liability cap is a commercial decision for your business. So the key here to think about is it reasonable? And then secondly, is it within your insurance cover limit? And if there's anything you take from this webinar today, and this goes across any commercial contracts as well, a general rule of thumb is your liability cap should never exceed your insurance cover limit. You don't want to overpromise and then not be insured for the risk. So it's always a good idea to ensure that your potential risk under your contract is within your insurance limits. Okay, so we've discussed capping your liability. Last point on this slide, excluded heads of loss. So you need to ensure that you include terms that limit the scope of what you can be sued for. So let's imagine, for example, your software goes down for the day. You've had unscheduled downtime, and as a result, your customer has claimed they've lost profits, or maybe they needed to find alternative services as a result. Now, if you don't clearly state that you're not liable for these kind of losses in your contract, then you can be on the hook for reimbursing the customer for those damages. So if you list those losses that you're not responsible for, things like, got it here, wasted expenditure, loss of data, cost of procuring replacement services, then you're reducing your liability for issues that are beyond your control or just too remote. So like data breaches caused by third parties, or disruptions caused by external factors. So to summarize, list the types of losses that you are not liable for, and then make sure you've got that liability cap to limit the amount that you can be sued for if you breach the contract. So now I think I've just about covered it for liability. Heather, I'll pass over to you to talk about protecting your IP rights.
Thank you. So as well as the points that Ashleigh's covered, it is also really important to make sure that you use your SaaS agreement to protect your ownership of intellectual property in your SaaS product. Before I move on to the next slides, I'm just going to answer one question that I've spotted that's come in because it's kind of relevant to the webinar as a whole. So I think it's better to just say now rather than wait till the end. So it's a question from David saying, does the software service have to be cloud-based? So when we talk about SaaS, we are talking about a cloud-based software service. That said, if you are providing software that's actually installed on your customer's device, a lot of the principles, if not all of the principles Ashley's just covered, are still relevant. It's just you would have a different type of contract. So instead of it being called a SaaS agreement, it would just usually be called something like a software license agreement. But a lot of the principles, so certainly around things like liability and warranties and those types of things, are still relevant. And the next section I'm going to cover kind of about IP is definitely still relevant. It's just that you would have a slightly different type of contract. So just go back to the slides. So back to IP in the SaaS agreement and how you can actually use your SaaS agreement to help protect your IP. So as you can see on the slide there needs to be a distinction between customer data and your IP as a SaaS provider. So it's all about setting boundaries so both parties know what they own and what they don't own. So customer data is basically any data or information that's provided by the customer through their use of the SaaS product. So it's usual for that data to remain the property of the customer, and that's usually the case whether it's data that they're inputting into the product themselves, or if it's actually some information they've sent to the software provider to input on their behalf. On the other hand, any intellectual property, including the software itself or algorithms or other proprietary technology in the SaaS product, should remain in the ownership of the SaaS provider. So the terms of the SaaS agreement should make that distinction, so ownership of different types of IP is really clear and there's no confusion in the future about who owns what. Another really important provision in the SaaS agreement is the actual licensing terms. So they define how your software can be used by customers. So licensing isn't just about allowing access to your product, it's really about controlling the uses rights and ultimately protecting your IP by doing that. So you'll see on the screen there's different types of license that you can grant. So for example, it can be perpetual or fixed term, it could be exclusive or non-exclusive, or transferable or non-transferable. There are different types of licenses as well. They're just some very common ones that come up in software provision. So we pick them as kind of headline examples. Each type of license does have implications on how your software can be used and distributed. So it is really important to think about the extent of the license that you're willing to grant. So for example, if you were to grant an exclusive license to one customer, that would limit your ability to grant the same license to other customers in the future. And likewise, if you have a fixed term license, that might mean your customer could use the software for a fixed period, so maybe for 1 year. Whereas if it was actually a perpetual license, you're giving them indefinite access to your software. So you should think really carefully about which license types make sense for your business model. And then those terms of the license need to be reflected in your SaaS agreement. It's also important to think about usage rights and restrictions. So for example, a license might be limited to a specified numbers of authorized users. So it might be that you have a SaaS agreement with a business, but you say they only have licenses for 10 authorized users in their business. So 10 of their employees can access the software. That can help prevent unauthorized access and ensure that the use of your software is in compliance with the agreed terms. Other restrictions could include location restrictions. So it could be that you might have a license that's only granted to individuals in certain countries or territories, and it's not available for use worldwide. Again, whatever you decide in terms of what the restrictions should be, it's really important to put them into the SaaS agreement. Properly structuring your licensing terms through defining ownership of IP and types of licenses and usage restrictions can really help to ultimately safeguard your IP, because you know that your software is being used in the way that you're allowing it to be used. So strong SaaS agreement that protects IP can be your first line of defense against misuse, infringement, and legal disputes. As well as using the SaaS agreement itself to protect your IP, there are some other steps that you should consider taking as a software business or a technology business. So first and foremost, you should ensure that your brand name, logo, and any unique product names are actually registered as trademarks with the UK Intellectual Property Office, who they're commonly referred to as the IPO. When you get these slides, there is actually a link there to the IPO's website as well, where you can look at how you can register your trademarks. If you do register your IP, it provides the legal basis for protecting your brand against infringement down the line. So that's why it's so important. Next, if your company has employees or if you use freelancers, it's important to make sure that your contracts with those employees and freelancers include clear terms stating that any IP created during their employment or their service is owned by your company and not by them. That can prevent any ambiguity about IP ownership and future use, or prevent a situation where you're unable to use some IP in the future because it's actually not owned by you when it should be and you thought it would be. That's particularly important if your business relies on innovation. So make sure your developers aren't walking away with your IP when it's actually you paying them to do their work on your behalf. Finally, you can consider utilising NDAs. So non-disclosure agreements are essential when you're discussing sensitive information with contractors, partners, or even potential clients if you're going into a big project with a new client. NDAs can help prevent unauthorised disclosure of your IP and other commercially sensitive information too, so they are a really helpful tool to consider. So we've covered the key elements of SaaS agreements, but there are some other legal documents that are also relevant to SaaS providers or software providers generally that I'm going to just touch on briefly over the next few slides. So first is a service level agreement, or an SLA, as it's commonly referred to. So an SLA basically defines the level of service and support that you'll provide to your customers. So it typically includes performance standards like uptime guarantees or response times for support requests. It'll also set out any remedies in the case of service disruptions or if you fail to meet those promised service levels. So they're often called service credits, those remedies. SLAs can be really helpful for ensuring there's a clear understanding between SaaS providers and their customers, and they tend to promote accountability on the SaaS provider's behalf and therefore lead to kind of positive working relationships. They are very common in the software industry, so customers might expect service levels to be offered, and if they aren't included, they might ask for them. Sometimes the SaaS agreement itself will just contain a clause that deals with service levels, but other times they're set out in a separate agreement. So that's this SLA that I've just talked about. Next is an end user license agreement. So that's commonly called a EULA. So a EULA is the legal contract between you as a SaaS provider and the end user of your software. So it'll outline the terms under which the user can access and use your software. So it includes things like restrictions on use, warranties and disclaimers, so some of the principles that Ashleigh's covered earlier. So how do EULAs and SaaS agreements actually work together in practice? So if we were to take Docue as an example and say Docue was looking to license some HR management software. So Docue as a business would enter into the SaaS agreement with the HR software provider. But the end users of the platform, so Docue's employees, may be asked to agree to a EULA the first time that they access the software. So in that case, you can see you'd have both a SaaS agreement and a EULA, and they kind of work side by side. Finally is a data processing agreement, or a DPA. So a DPA is the legal contract that governs how personal data is being processed. So under the UK GDPR, which is one of the kind of key bits of data protection laws in the UK, it is mandatory for all controller to processor relationships to have a DPA, and you can see on screen there it's kind of an explanation of what a controller and a processor is. It is very common for SaaS providers to be processors of their clients' personal data. So for example, if we were to look at that HR management software example again, the client might put personal data of their employees into that software. The client will be the controller of that personal data, as they're the decision maker in relation to it, and it's personal data that's within their ultimate control. However, if the SaaS provider has access to that personal data or handles it in any way in order to provide the software service, they would be the processor of it, acting on their client's instructions as the controller. So as in that case, there would be a controller to processor relationship. A DPA would be required to comply with data protection laws. Failure to have one would be a breach of data protection laws, and with any breach of data protection laws, you could be investigated by the ICO, get claims from data subjects, or even be subject to monetary fines. So that's a summary of the key aspects of SaaS agreements and some of the other legal documents that are relevant to software providers. All of the legal documents mentioned today are documents that Docue has legal templates for. So I'm just going to very quickly change how I'm sharing my screen to show you the Docue platform and how you can use Docue to help produce those documents. So hopefully on screen now, you can see the Docue platform. So I've pulled up our software as a service agreement template because that's the kind of main document we've talked about today. But a lot of these principles apply to all 150 plus of the legal documents that we do have. So how it works is this middle section is what we call the document builder. So anything that you input or change in this section will cause your legal document to be updated in live time, and you have a preview of that on the right-hand side. So for example, if we wanted to rename it a SaaS agreement, you'll see that's updated on the right-hand side. Or if I want to show my company's logo, that's been added to the document. All of our legal documents then have this kind of content section at the start. So we'll pre-tick some sections that would say are generally standard to include in that type of document, but then you can fully customize it to suit your business needs. So if, for example, you did want to include service levels in your SaaS agreement, you just ticked that, you'll see it's added that as a new clause 7 here, and the rest of the numbering's all been updated. In terms of creating your legal document, it really is a self-serve platform. So you just work through the various sections and complete them. And like I said, as you complete any information on the left here, it's automatically added to the preview of your document on the right. With this document, we have two versions. We have a more supplier-friendly version or a more customer-friendly version. So if you're the software provider, you would use the supplier-friendly one. But if you were procuring a software product, you might want to change it to the customer-friendly one, and the terms automatically update for you based on what chance you select there. You then just work through the sections. You'll either get text boxes like this, where you just type it in whatever you want and it appears in your document, or some sections you'll see more tick box answers. We include a lot of information boxes throughout, so if you're ever unsure of what the answer to a question is or how to complete something, you hover over the information boxes. That gives you some guidance to help you. Once you've created your document, you can then use Docue to send out for signature as well. So we have e-signature service built into all our subscriptions, and you just press this teal button at the end here and you'll get a pop-up asking if you do want to use the e-signature function to send it out. So that is a very quick run through of the Docue platform. I'm conscious it's very quick because of the time. So if you would like some more information about Docue, including the opportunity to kind of explore the platform for yourself, if you visit our website, you can either book a demo or sign up for a free trial through there. So please do that. So on to some Q&A. So
yeah, we've had some great questions come in. So Matt Wilson, thank you for your question. Yes, with third-party software, I mean, typically you'll see an obligation ensuring that the customer agrees to those third-party terms within your SaaS agreement. And yes, that's right. You would include the name of the company, title of the terms and conditions document that they will be agreeing to, and also, yes, a hyperlink. And another very common thing that you'll see in SaaS agreements here is after that hyperlink, there'll be some wording, something like such terms may be updated from time to time. And this just ensures that if that third party does update their terms, then you've catered for that, and you've preempted that potentially they could change over time. So thank you, Matt. That was a really good question. Another really great question is from Deborah Kent. So Deborah has asked, what happens if a client refuses to agree to my liability cap or insists on a much higher cap, and how do you negotiate that? This is a great question, something that I dealt with quite a lot within private practice. And firstly, I would ask the client, why do they need a higher liability cap? What are their main concerns here? And open up dialogue with them and try and find out what their their worry points or their risks are in entering into that contract with you. And usually once you've teased out those risk areas for them, then you can start thinking about ways that you can assure them. So say you've got internal processes or technical measures that might be able to offer them some comfort about your contract and that you've got those kind of issues covered. Things like, say it's data they're concerned about. If you've got certifications like ISO 27001, those are the kind of things that actually, if you start talking with them, let them know that you have those in place, then they might realize that actually those risks are covered and the liability cap is fine as it is. Also, it's good to explain why your level of liability is at what it is. So it might be industry standard, or it might be, as I said earlier, proportionate to the value of the contract. But with that being said, if that's not good enough, or their concerns aren't addressed based on opening that dialogue, then maybe you could think about offering a separate liability cap for them, which is sometimes known as a super cap, that cover just those specific issues that they're concerned about. So, for example, going back to the data point, if they're concerned that you may breach data protection obligations or confidentiality, then you could just offer them that separate higher liability cap to cover breaches relating to those issues. So you have that separate liability cap, but you also keep the lower general liability cap for all other risks across the contract. So this allows you to tailor that contract to your client's specific concerns without exposing your business to a high level of liability across the board. So in summary, address what their concerns are, see if there's a practical way to address it, and if not, offer a separate super cap. Hopefully that answers it for you.
Great. Another question has just come in. I am conscious of time, so I'll be quick. But in terms of the name of the agreement, you can call it what it wants. It doesn't affect its legal impact. The title can be what you would like it to be. That said, there kind of are much more industry standard titles that customers might feel more familiar with. So SaaS agreement is commonly used where it's cloud-based, and then software license agreement or license agreement tends to be used more where it's software that's not cloud-based, so if it's actually installed on a device. But as long as your customer kind of is clear about what it is, you can call it what you want, and it doesn't affect the legal enforceability of the contract. There are a couple more questions, but they require slightly more detailed answers, and I'm conscious of the time. So I think we'll follow up with you offline, if that's okay, for those two remaining questions, I think it is. The final thing just from us is just to say, when you do get the slides, you'll see on that last page there is some links. One of them just takes you to our legal template, so you can have a look through there. Like I said, we've got over 150 in the UK and should cover a range of different business needs. And there's also a link to our legal hub. So you'll see that's on our website, and then the legal hub basically contains lots of guides, Q&As, checklists and things like that on a wide range of legal topics. So you can use the search function if there's a particular legal topic that you're interested in, or if you go to that technology folder, which I've linked, there should be lots of hopefully helpful resources for you there. Thank you very much for joining today. We really do appreciate you taking the time, and we hope that you found this session useful. And yeah, enjoy the rest of your days. Thank you very much.
Thanks, everyone. Bye.